All right. Please take your seats. Caribbean Court of Justice Appellate Jurisdiction on appeal from the Court of Appeal of Barbados, CCJ application number 1 of 2018 between Dwayne Mary O'Neill versus the Queen for the hearing of the application for special leave this morning. Can we have the appearances for the court, please? Thank you.
It pleases this honorable court. I'm Andrew Pilgrim, and I appear on behalf of the intended appellant applicant, and with me is my learned friend, Mr. Kyle Walks.
This honorable court. I am Crystal Delaney, and I appear on behalf of the intended respondent, and with me is Mr. Neville Watson.
Yes, thank you, counsel, and good morning to you both. Mr. Pilgrim, before you begin, is the accused, is the applicant still in custody? Is he still serving a sentence?
He is, Your Honor, and we were just trying to confirm the exact date, but we believe he's due for release on a day in March of 2020. He has a few months yet to go.
I see. Okay. Yes, go ahead.
Your Honor, I wonder if, subject to the court's views, we could deal with the issue of the constitutional ground first, simply because I imagine that should give us a certain amount of clarity in terms of the way forward once we know where we stand on that issue.
Yes.
It's our contention that the judgment of the court, as given as a unanimous judgment of the 3 judges, purporting to be judges, a panel including Justice of Appeal Mason, is flawed for the reason that at that time, Justice of Appeal Mason would in fact have been Dame Sandra Mason, Governor General of Barbados. And it's our view that that offends against the principles of separation of powers, as stated in Hines and stated in Mollison, and that she ought not to be part of any tribunal that would be giving judgment in a criminal case. And that her deliberations...
It was a unanimous decision, wasn't it?
Yes, Your Honor.
Okay, so without prejudice to that other point, even if her judgment in the matter, her opinion is disregarded, then wouldn't there be a majority that dismissed the appeal?
Your Honor, it's our submission that that would be so if, for example, Justice of Appeal Goodrich had written a decision with which her 2 colleagues had agreed. But this is a case in which the 3 parties purported to give a judgment in which they all agreed. In other words, they all contributed to the deliberation and judgment process as I understand it. It's not a case of the other 2 agreeing, in which case I think it would be quite fair for the Crown to argue that Judge number 1 wrote the judgment and Judge number 2 agreed, and Judge number 3, who doesn't qualify, also agreed, and we just take out number 3 and proceed.
Sorry.
But in
help me here. I see it's a decision which is delivered by Justice of Appeal Goodrich.
Yes, Your Honor. But she says very clearly throughout that decision that it is the decision of them all.
Right.
And they refer throughout the decision to we doing this and we decided this.
Right.
And we, etc.
Right.
And I'm seeking to argue that because that tells us that the decision process was a unanimous decision made by 3 parties, that the decision of the other 2 is tainted by virtue of the fact that the person who has essentially is not entitled to be a judge and may have motives pursuant to the motives of the executive is deliberating with them in that process. And it is impossible in our submission to extricate her from that process.
That, to my mind, counsel, is a far reach that you are making. There is not any factual basis for ascribing even the possibility of having a motive. Let me tell you what has engaged me with this, and perhaps it may bring clarity to our discussion.
Grateful, Your Honor.
Sorry, yeah. What has engaged me is that this is not a situation where, for instance, a function entrusted to the judiciary is being performed by the executive, as in detention at the pleasure of the Governor General, etc. This is simply a situation where a function entrusted to the particular person is performed by that person by virtue of the capacity conferred to that person as a judicial officer, and it is simply that upon the expiration of that tenure, the person continued by performing one simple act in the capacity of a judicial officer. So it's not that the Governor General is purporting to be a judge. It is that the person who is now Governor General is saying, by virtue of having been a judge, I will do this one final act.
I understand, Your Honor, your position. I, however, cannot agree that it is one simple act.
Okay.
It is the deliberation in circumstances that she and two other judges, at a time when she is no longer a judge. And if we were to take another example, if the person had gone on to become the DPP, there would definitely be a problem. It would be more obvious, I think, in the sense that it would be highly improper for a DPP to be sitting in judgment on a person who's at the prison.
When did the,
Our argument is-
Mr. Perry, when did the deliberation take place?
Sometime at a time when she was the Governor General, as far as we can
How do we
determine.
know that?
Well, I don't think we can assume it is otherwise.
Why couldn't the deliberation
we
have
assume it
taken
is a-
place the day immediately after the hearing?
Your Honor, if I perhaps lived in another jurisdiction where deliberations take place and decisions are given in a reasonable time, I might accept that position. But I live in a country in which we never get decisions within a year.
No, wait, just now.
Yes, Your Honor.
Is there anything to suggest that the deliberation did not take place immediately after the hearing, and that it is simply the drawing up of what was decided that took place on the 23rd of October?
Your Honor,
Yes?
we're losing you a little bit, Your Honor. We're not hearing, we didn't hear anything that you said just now.
Okay, I'm saying that.
I don't think it's your fault.
Are you hearing me now?
Yes, sir.
Okay. Is there anything to suggest that the deliberation may not have taken place immediately after the hearing, and it was simply that the acts of writing up what was deliberated upon and agreed, and delivery of what was written up took place after Dame Mason became Governor General?
Your Honor, there is no suggestion that it did, and there is no suggestion that it didn't. In other words, your Lordship, Your Honor's court could assume that it did.
So the
But
rule
there's
of
nothing to
omnia
suggest that.
praesumunta applies. Everything which is presumed to be rightly done was rightly done. Why wouldn't that apply?
So that we would but Your Honor, how could we possibly presume that the practice in Barbados, for example, is that
No, I don't want to know about the
deliberations take
practice
place
in
the day after?
Barbados. I want to know about this case, and whether
But
there
Your
is
Honor,
anything to
this case is
suggest.
taking place in Barbados. It isn't taking place in Japan.
No, I'm talking about this case, and I'm talking about
Yes,
what
Your Honor.
may or may not have occurred in this case, and what is the evidence in this case that exists or does not exist.
There is no evidence.
Well, then why doesn't the rule, the Latin maximum of everything which is presumed to be rightly done is rightly done? Because to
And the
me,
maximum
it
sorry,
is
sir.
not inconceivable that after a hearing, a collegiate panel will discuss what they heard and then would
What
assign
panel, Your Honor?
an appellate panel,
Yes,
a
Your
panel
Honor.
of more than one judge, will
Your
discuss
Honor, I
what
just
they
didn't
have
hear you,
heard, and then they will say, well, okay, we agree that this is our position, and we would assign X to faithfully record, to write up the judgment of us all. And X might take a week, he might take a month, he might take a year, he might take 4 years. So,
Your Honor, it sounds good, Your Honor. Sounds good. It's very attractive. If we want to get around what is the known practice, I think that is one route that one could adopt. But the assumption that that takes place, that is the right thing, is itself an assumption, is it not?
but
No,
equally,
it's
you are
one thing to say
assuming that
it's the
that
right
did
thing.
not take place. You see, that's the realm in which we are. You're assuming that it is after Dame Mason became Governor General that they suddenly realized, ouch, we have to give this judgment. So let's the two of us and the Governor General deliberate on this case and then give a decision. Now, why should we assume that that took place?
Your Honor, the alternative is to assume that they did the right thing on the day after the arguments and waited for 5 years.
So,
That's the alternative.
yes. And why can't we presume that? Why must we presume that they did the wrong thing, the bad thing?
Your Honor, to assume that they did the right thing is to assume they did another wrong thing in itself. In other words, to assume they did the right thing the day after and waited for 5 years would suggest that the decision in itself would have certain inherent flaws, humbly. So you wait for 5 years, having deliberated, and then decide to write the decision?
But
It looks, on the face of it, sorry, Your Honor.
you're talking about what is the practice and so on. I have been on appellate benches for the last, maybe 17 years, more than 17 years.
A long time, Your Honor.
And that often happens. Immediately after you hear the case, you discuss, you agree, you assign somebody to write it, and sometimes that person takes a long time, a very long time.
Your Honor, I completely agree with you, but I don't think that we can assume that the standard is that all appellate tribunals meet the day after or immediately after and make those arrangements. One, and two, that has not been my experience.
Okay, we hear you on that one. So there's another issue on the constitutional point that you're making, a wider issue, which is that whether they deliberated on the same day or not, the point is you have evidence that the Governor General signed the judgment on when she was Governor General. And you're saying that that vitiates the judgment without prejudice to whether they might have deliberated immediately after the hearing or not. Am I correct? Is that your argument as well?
Well, Your Honor, I had not formulated that argument in relation to the idea that they had deliberated on the day after, which humbly I think is an assumption as opposed to an applying of a maxim of rightness. I think it's an assumption, which is just, we would be basing it on experience of some people. I don't think we could take that as the right thing, humbly. But we are also making the point.
So when do you think they deliberated? Sometime after Dame Mason became...
I think they deliberated the day before they gave the judgment. But that's just what I think. You think they deliberated right after, and I think they deliberated
I
right
really
before.
would need, from my own experience, to share with you that that is a virtual impossibility. A judgment such
Welcome
as...
to Barbados, Your Honor.
No, I'm talking about the written document which we have before us.
Yes, Your Honor.
That could not be produced in a day.
going to say a day, maybe 2 days before, 3
With
days
the
before.
greatest of respect, Mr. Pilgrim, I'm telling you from having written judgments, not as long as my brother, but over a goodly number of years, a judgment like this is not written over a day or a week or 2 weeks. Yeah?
It simply
It's
doesn't
written
work
over
that
3
way.
months. And then, I completely understand, Your Honor. I understand your point. But I don't think, the real question for me is, what is it that provoked this panel, 5 years after hearing the argument, to give a decision?
Mr. Pilgrim, I'm trying to come to terms with your 5 years
Yes.
after. And I see from the judgment of Justice of Appeal Goodrich that she mentioned in paragraph 27 that the Court of Appeal heard the matter on the 31st of May 2017. So because
Sorry, I'm
you would
misleading
recall
the
that
court. It is
another
a year.
counsel was in the matter and you happily volunteered to assist. And the Court of Appeal was very grateful and they expressed that 25, 26 paragraphs and then 27. Justice of Appeal Goodrich mentions that it was heard on the 31st of May, so 2017. So I'm not sure where you got your 5 years from.
I'm sorry, Your Honor. I am misleading you entirely. It is not, it's in fact a year and a half or so.
Thank you.
And Mr. Pilgrim,
Your Honor.
before we go further,
Apologize for that.
Mr. Pilgrim, may I, and I'm
I'm
sure
hearing
on
you, Your
behalf of my colleagues, also celebrate the generosity and the professionalism which made you offer your services to take this matter on. It is the sort of tradition which I think we all, judges and lawyers, are happy to see being vindicated.
I'm grateful to you, Your Honor, but I have to say it was such a sad situation that the appellant found himself in. I could do no less. It was a situation where a lawyer had taken fees from the young man and promised to appear on a number of occasions, didn't appear, and then the next thing we heard, he was a minister of government in the Bahamas or something like that. So the young man was there alone, and the court was saying, let's go ahead.
Well, what I don't
So we
understand
had-
is that a court does not stop this. How can you accept a lawyer who promises to appear and doesn't appear? There must do, anyway, that is not the way to do things, as I see it.
Indeed, Your Honor.
But coming back to this point, now, if I understand you well, you're saying, okay, because it was a unanimous decision, that's why we have this particular problem. If Goodrich had written the judgment and the two other judges or former judges had said, I agree, that would not create a problem. Is that correct? Is that what you're saying?
I think that's fair comment. Yes, Your Honor. Yes, Your Honor.
Isn't that then a little formalistic
Artificial.
and artificial? Because we know how these things work. I'm not sure, I don't know if they deliberated the day after, but usually very shortly after you hear a case and then somebody is assigned, as the President said, and that person can take a long time, and clearly in Barbados there are many cases to point at where it takes too long anyway. But that's a different matter. This is how it usually works. And so if it is then that that just a change of formulation in the decision, that would make all the difference. I would be very slow to follow that. I mean, everybody
In
can
other words-
agree that
Sorry, Your Honor.
this is not a happy situation, but that's a different thing from a violation of the separation of powers, clearly.
But so Your Honor, would Your Honor be content to say that if the deliberations took place sometime when she was a part of the executive, that would not be a problem?
Well, we don't want to say
Yes,
one way or the other.
exactly.
The point is that without any evidence either way, then the maxim that all things are presumed to be done in due form is unassailable.
It's also quite
Your Honor,
interesting, Mr. Pilgrim, that you seem to have asked a relevant question Was it of the registrar when you asked when was the judgment signed? I noticed. That was the precise question that you asked.
I think that's correct, Your
And
Honor.
I think the response was something like the 23rd of, is it October?
Yes.
Yeah, but you restricted your question quite maybe astutely to the signature. You did not go into the question of the deliberations.
And indeed, I think it would have been out of place for you to ask that question, quite frankly.
I should,
And
Your
equally
Honor.
out of place for the registrar to give a decision, to give an answer. But the registrar
answer.
would not know, or not to know.
But I think that the answer came from the court. But I think it's neither here nor there whether I asked that it just seemed unusual to me. And I think that if I was doing the right thing and I had deliberated at the right time and the decision was given at the right time, essentially, I would have said so if I were in the position of the court. But I unfortunately was not in the position of the court. But my query for this honorable court is it fair for us to say, applying the maxim that we want to assume that the right thing was done, is it fair to say that the right thing is that they deliberated at the appropriate time? Isn't that an assumption based on your Honor's experiences?
The point is,
As opposed to
the point
the
is,
right
Mr.
thing.
Pilgrim, that in the absence of evidence one way or another, we cannot ascribe to officials that they have done the wrong thing. That is what you are asking us to do.
Your Honor, I think that there is some evidence that they didn't do the right thing, to be fair.
Okay, put it this way. Giving a judgment after 3, 4, 5 years, whatever the time period is not the right thing.
It's not that long, to be fair.
In excess of 6 months, without good reasons, is not the right thing. But
Yes, Your
you
Honor.
don't want to stop there. You want to say that they deliberated when Dame Mason was no longer a judge. Now, there is absolutely nothing to suggest that they did or they did not. And in the face of that, it would be very invidious for us to suggest that they did deliberate when she was no longer a judge. Now, this is without prejudice to whether it is even improper to do that according to the laws of Barbados, which is another issue, which we haven't gotten to yet. But let us deal with the
Yes,
first
Your
issue now, and that is
Yes, Your Honor.
whether there is any evidence to suggest that they even deliberated after she had retired and had taken up another position. So we've gone round and round that thing. Let's go to the other issue.
Yes, Your Honor. Yes, Your Honor.
Doesn't the Constitution of Barbados allow for a person who was a judge to do what is necessary to conclude a matter that was commenced before that person?
Yes, Your Honor.
So then what is the complaint in this case?
But the complaint only exists if we don't get past the first argument.
Exactly.
I don't think I can make that complaint if the court is of the view that we are assuming that the right thing was done.
Yeah.
If it is correct that the right thing was done, I think the second argument goes.
Okay.
Very well.
Well, we
'Cause I think
appreciate your
she's
candor.
entitled to give a decision. But we've got to be straightforward with this court. I think if she was essentially a judge at the time that the deliberations took place, I can have no complaint on that score.
But I want to go a little further to suggest that even if she were not a judge at the time the deliberations took place,
Yes, Your
what
Honor.
is your view on what the Constitution says? Isn't there something in the Constitution that says if a person has retired, if the person is no longer a judge, then they can do those things which are necessary to conclude matters that were commenced before them?
Yes, Your Honor, but I think there would have to be certain exceptions to that. I think as a matter of principle, if a person was sitting as a judge, for example, I like the example of a DPP. If you're sitting as a judge and you then were to, by some quirk of fate, to become the DPP, it would be inappropriate for you to write a judgment that says anything about the disposition of that appeal that you sat on. I think that it is fair to say that if you're a judge at home sitting down, having retired, and you're not in any office that presents a conflict or a bias or puts you in an arm of the government that you should not be part of when giving a judgment, I think you're fine. But I think that the Constitution protects persons who are not in a position that is contrary to delivering a judgment in the ordinary course of things.
Well, you see, what is happening there is that there's a tension between two values. One is the appearance of natural justice, and the other is a specifically laid out constitutional provision. It's not in an ordinary act. It is in the fundamental law that says that you can sit as a judge for the purpose of delivering judgment or doing any other thing in relation to proceedings which were commenced before you. Now, how do you resolve that tension? One, which is a specifically laid out provision in the Constitution, and one which is a principle which you can extract from the Constitution as well, principle of natural justice, and you would say in this case, separation of powers. I mean, in your example, the DPP clearly couldn't do anything in relation to that case in his job as DPP, and then still be either deliberating or signing the judgment. Then that's a different kettle of fish. But if he only or she only completes that matter that was commenced before him or her, without, in his role as DPP, doing anything in relation to that particular case, would they violate the Constitution?
In my view, it would. If I take on an office where my responsibility is such that I am responsible for prosecuting persons, it would be inappropriate, in my view, for me to be deliberating on the fate of the persons who I am now required to prosecute.
No. He's not required to prosecute Mr. Neal. Mr. Neal is a case.
Well, you might be. In other words, you might order a retrial, for example. In other words, in those deliberations, I may be willing to concede certain issues vis-a-vis certain types of conflict. But I cannot envisage that a DPP in any circumstances could be signing a document as a judge, because part of that judgment might involve returning that person to litigation.
No, in that case, he would have to recuse himself. But anyhow, that is not happily the situation before us.
Indeed.
So, well, I think you need to go on to your arguments on the substantive issues other than the constitutional point, because we've kind of exhausted.
But, Your Honor,
yes?
I just want to make, with your leave, just to make the point that if we have to deal with the deliberation as being done at the right time, we don't have a problem.
Okay.
But it's our submission that if the court were to form the view that she was deliberating at a time when she was in fact a part of the executive, then we would have a problem, in my humble submission.
Okay.
And it would be my argument that her being part of the deliberation process as part of the executive would be inappropriate and unlawful and contrary to the fair trial provisions of the Constitution.
Clear. Okay.
And to the doctrine of separation of powers. But I think that in dealing with part one, I think we get past that. Now, I think that's that on the Constitution.
Yes.
Right.
Your Honor, I just wanted to draw a case to your attention because it came to my attention last night and served my friend with it very hurriedly. And it's just really to support that last point. And it's a case called Stubbs and the Queen, Davis and the Queen, and Evans and the Queen.
What's the first name? Stubbs?
Double BS and the Queen, Davis and the Queen, and Evans and the Queen. And it's from the Court of Appeal of the Commonwealth of Bahamas, appealing to the Judicial Committee of the Privy Council, and it's listed as Privy Council Appeal numbers 15 and 16 of 2017, and numbers 98 of 2016.
Yes.
Cited as 2018 UK PC at page 30.
Sorry, repeat?
2018 UK PC at page 30.
Thank you.
And I'm just mentioning it because I think it's an interesting, maybe at this stage, academic interest. It was a situation in which a judge had sat in a murder trial, which was abandoned, I think, on the last day, like during his summation. He then went on to higher office. The matter was retried because it was a mistrial declared on the last day of his trial. And he eventually found himself sitting on an appeal after maybe two subsequent trials for the same case. And the appellants asked him to recuse himself, and he refused. And because there were particular matters that he ruled on in the first trial, the Privy Council made the decision that it was inappropriate for him to sit on the appeal, and therefore allowed the appeal, etc. But in their paragraph, I think it's 33, they make a comment about the impact of him sitting with two other judges and whether it would have any impact on the other two. In other, the type of situation that we're looking at in terms of whether any problem with one judge could impact or affect the judgment of the other two. I'll just read that paragraph 33, it's not very long.
Yes, sure.
Finally, contrary to the view of the Court of Appeal, the fact that Justice of Appeal Isaacs was not sitting alone to hear the appeal cannot assist the respondent. The whole point of the appeal was that three judges should consider the issues afresh and without any predetermination or prejudgment. If there were valid grounds requiring Justice of Appeal Isaacs to recuse himself, they apply with equal force whether he sat alone or in company. Each member of the Court of Appeal will have played a full part in the deliberation and resolution of the issues raised on the appeal. The mutual influence of each member of the court over the others necessarily means that if any of them was affected by apparent bias, the whole decision would have to be set aside.
Okay.
As I say, this may be purely academic now, Your Honor, but I just thought it was sufficiently close in terms of the possible impact of one judge being, for want of a better term, tainted, how it would affect the rest of the judgment.
Yes.
Yes.
Thank you, Your Honor. Your Honor, as much of the rest of the appeal turns on questions that arise when a man is at trial in his absence and relate essentially to the interesting facts of Dwayne Neal, where Dwayne Neal, for want of a better term, took off early in his trial.
May I say it's a refreshing description of what took place? Refreshing. Took off.
He did not appear when called for, Your Honor. And the trial continued in his absence. Much of what was canvassed in the Court of Appeal turns on how far a judge has to go when he makes the decision to exercise his discretion to continue in the absence. Now, humbly, it's our position that this is a very rare occurrence in Barbados, to begin with, I should say. But putting that aside for the moment, it's our submission that the judge who takes on the role of continuing the trial for the unrepresented and absent man takes on an extremely high duty in our submission and puts himself in a position where he is virtually, because he's already got certain duties to the unrepresented man, facing, in this case, a very heavy sentence as a possibility. But he then also now has to take on the role of assisting the defense when the defendant is not present. The alternative was to order a new trial for the appellant. And it's our submission, essentially, that the possible prejudice to the appellant is far outweighed by him having to suffer through a trial in his absence, when balanced against the idea of doing a new trial for him whenever he is found, which in the context of our 166 square miles is usually very soon. So that in this particular case, the learned trial judge had to make a decision after the application was made by the Crown to continue the trial in his absence as to whether to continue on, and in our submission, whether he was able to conduct the defense essentially on behalf of the defendant in his absence. And it's our submission that in the particular circumstances of this case, that he failed.
So could you tell us what he should have done?
What he should have done is abandon the trial in respect of that man,
You should have abandoned the trial.
in respect of the man who was absent.
Yeah.
Or if he didn't, could he have done more? If so, what?
If so, he could have appointed counsel pursuant to the Community Legal Services Act to act for the man. But even that would be difficult because counsel coming in would know, I imagine, very little of the defense and would not have the opportunity
To be briefed.
to
There
They
is a
have no
provision,
instructions.
Mr. Pilgrim,
indeed, milady.
in
Your
Haywood,
Honor.
it was quite
Yes, Your Honor.
attractive in paragraph 5 of Haywood. The
Mr.
last,
Solly QC.
yes, the last line of that paragraph, the court in Jones number 2 emphasized that it would not countenance putting a premium on jumping bail. Just a thought that for the judge to abandon the trial would seem to come pretty close to putting a premium on jumping bail.
I'm just looking for the quotation. Oh, yes, overly, beg your pardon. Your Honor, the challenge is, whatever the judge does, he must ensure that the trial is fair, whatever he does. So the question is, regardless of, obviously we don't want people to jump bail, and indeed people can be punished for jumping bail. But in our view, that is a separate issue. When once you take a decision to continue the trial is not a punishment for the jumping the bail. The trial must continue in a manner that is fair.
Right, but it has to be fair in the circumstances, including a major part of those circumstances being that the person who had the obligation to himself to put forward his defense has chosen to not put forward his defense. So that is the circumstances in which, or the circumstance in which the judge must ensure fairness. He cannot undo the absconding of the defendant. He can only take it forward given that the defendant has absconded and has put himself at this disadvantage.
Putting it another way, Your Honor, we then need to inquire humbly what responsibility does the judge have to the absconded defendant? In other words, is it that whatever happened, fella gone through the door?
No, I think your submissions rehearse these very fully and ably.
I'm guided, Your Honor. So
But of course, you also would agree that maintaining the fairness of the trial is not just the fairness for the defendant, but also fairness for the society, for the prosecution, etc. So,
indeed.
There's another sentence in Jones which is also fascinating. Unfortunately, I don't have the actual paragraph, but it may sound familiar to you. Lord Bingham in Jones was saying that if he, meaning the accused, voluntarily chooses not to exercise his right to appear, he cannot impugn the fairness of the trial on the ground that it followed a course different from that which it would have followed had he been present and represented. So I do take the point that the judge, of course, has to make sure the trial is fair, but there's also an obligation on the person who has absconded, and if he has not turned up to protect and assert his rights, then that has to be considered in the context of the judge being fair and making sure the trial is fair. The reason why he was not there is critical as well, is it not? If he was ill or incapacitated or for some other reason, but if he has deliberately absented himself from those proceedings, and he has told his sureties that he's running away, then yes, there is still a duty to be fair, but of course, as was said, that fairness has to be looked at in the context of the conduct of the accused. Surely.
I think I agree completely, Your Honor, but I think the danger is that the judge finds himself in a position where he more or less has to assume what the instructions or the brief would be, or he just does the trial with no assistance for the man. It was somewhat complicated by the shrewdness of the co-accused, if I could call it that, who said very plainly to the jury, I am an innocent man. If I was guilty, I would have run just like that fella, Dwayne Neal.
Which, Mr. Pilgrim, you are very familiar with the cutthroat defense that we often see, and you know that this is what takes place even in the presence of a co-accused.
Well, I think the unique circumstances would have lent support to the position adopted by the co-accused.
Indeed so. So Neil by his absence...
There was no better throat to cut.
Neil, by his absence, facilitated the exposure of his throat.
And this was not the first time that he had failed to show up, was it?
In terms of this trial, Your Honor?
Yeah, well, yes. I thought I read that there was another occasion where the matter was called and he wasn't available.
I think the case was adjourned several times.
The case was adjourned many times, and I believe at least on one occasion it was adjourned because he wasn't available.
We're losing some of the transmission. We're losing some of your audio, sir.
Yeah. No, I think we're just making the point that this matter had been adjourned on several previous occasions. I could be wrong, but I think on one of those previous occasions, the adjournment was caused by the unavailability of Mr. Neal.
We're losing all the audio, sir. I think we're having some slight technical difficulties on one end or the other.
Well, Mr. Pilgrim, we're hearing you very well. So, did you want to continue with your submissions?
We're hearing you well again, Your Honor.
We can hear you.
We're hearing you well now.
Okay.
We're hearing you well again, I think.
Good.
If you'll permit me the slight flippancy, perhaps all we need to do is not to talk and allow you to talk,
Yes.
and we'll have no problem.
Yes.
Yes. Mr. Pilgrim, there was one other
Yes.
issue that I was considering, and I wondered whether it had any impact on what the judge could have done in this situation. This was an act which took place in 2002. So a
Yes,
lot of
yes.
time had passed before a trial was fixed. And it appears that, as my brother, Justice Anderson, indicated, this matter came up several times before the judge, before he finally got it started. So was that something that the judge had to bear in mind? Remember, there is this issue of what the administration of justice must look like in Barbados.
Your Honor, I was just about to say that the challenge with a lot of our matters, for example, the trial there's a trial going on downstairs that finished yesterday, where the accused persons were 12 years old at the time that they allegedly chased one of their contemporaries into the street and he was knocked down by a car. And they're coming to court now as people with large beards and earrings and whatnot, 6 or 7 years after. The problem is that the timeline between our incident and trial is really typically between 7 to 10 years.
Yes.
So that the problems of getting trials set down is a serious problem, and the trial judge in this case no doubt would have been affected by the fact that the case in Dwayne Neal would have, it's an incident from 2002 going to trial in 2011.
Mr. Pilgrim, I hear what you say on that score about the young men yesterday in court. But think about a young girl raped at age 13, and the matter is not called until she's 26 or 27. She's now married with children. Is there justice for that sort of victim or survivor that we, as we like to refer to her? This is a very difficult issue, and something that I think not just the judiciaries of the Caribbean, but the bars, the criminal bars, have to look at too. You have a responsibility as well, your criminal counsel.
Absolutely, Your Honor. Your Honor, I think that it was not, a few weeks ago, I was having a conversation with my learned friend, Mr. Watson, on the other side, and saying that essentially the percentage of rape or sexual offense matters that actually come to trial in Barbados is extremely low. And it's because victims and so on are, you know, so happy to move on after the extreme delay and the, for want of a better term, the treatment of the matter over a period as long as 10 years quite often leads to all kinds of problems.
Yes, well, I've taken the matter. I'm sorry that I took you away from your submissions, but it's something that, as you mentioned, because as you know, the court has done a lot of work with model guidelines, how to handle cases of sexual offenses. And I just hope that it's not just a document in Barbados that is gathering dust, but that it is being used and applied. But you go ahead with your submissions, Mr. Pilgrim. Thank you for your responses.
Grateful to you, my lady. Your Honor, I think that the real question for this court at the end of the day, taking the constitutional point as we have and finish dealing with that, really it is a question for this court, whether in all the circumstances of what happened to Dwayne Neal, whether the judge did enough in his absence. And I think everything else really turns on that. And I rely on my written submissions, and unless the court wants to hear me on some other particular issue, we contend that once the decision is taken to continue the trial in his absence, the judge puts himself in a difficult position when we consider all the circumstances, all the delay, etc. He puts himself in a difficult position when he tries to take it on for himself. And unfortunately, in the context in Barbados, I think that a lot of people in a Dwayne Neal type scenario start to believe that their trial will never come on. And then when it does, 9 or 10 years later, they are so afraid and so unschooled in the ability to cross-examine, for example, in a case in which, in this case, the only evidence is confession evidence. They are so unschooled and unprepared for that event that when it happens 9 to 10 years after the event, they are afraid. They're unrepresented. There's no legal aid for a matter of this type. The judge is, you know, obviously trying to get matters on, prosecution trying to do matters. But at the end of the day, when the learned trial judge takes a decision in all these circumstances to continue with it, how could the trial be fair if the man's only defense is to cross-examine the police officers who say that he confessed? When his defense is essentially, if we read between the lines of what little we have from Dwayne Neal before his departure, is that the police are lying on him and that they used oppression to get him to sign a statement he didn't want to sign. It's really impossible to do that defense in his absence without some special brief, some brief from him. And we are submitting that in all the circumstances of this matter, it was inappropriate for the judge to try to do it at all. but that if he tried to do it, he really would have had higher obligations than just allowing the police to recite the statements and sending the matter to the jury.
Could you, what is his age, if I may ask?
Just Craven does just for a moment, Your Honor. 38 or something. He's nearing to 40, Your Honor, but we'll just try and get the date for you.
It was born in 1980, so it's probably 39, I think.
39.
39?
Should have just.
So he was about
39.
22, he was about 22 in 2002?
Yes, Your Honor. Yes.
Did he have a record?
Happily, Your Honor.
Did he have a record?
Assistant librarian in the prison. I think he did. Does he have a record? It's a criminal record. We're just checking for you, Your Honor.
Yes.
See if we can send us a request. I'm pretty certain he does, Your Honor. We're just checking the sentencing remark. At page 524, there's a reference to the 10 previous convictions. And they're at the, this would be, in the record of the, page 524 of the actual record of the appeal, they're set out.
What is the page, sorry?
Page 524
520.
of the transcript
The record.
of the trial. Yes, sir.
Okay.
And most of them appear to be similar in nature, to be fair. So that the first one, July 20th, 1998, this E-Magistrate Court had in his possession.
I was thinking.
On the third, Your Honor, is it useful for me to read through them, or?
No, I don't. Well,
No,
think
when
we
we
need
have the
to.
page, that's fine.
Grateful.
Thank you.
yeah. That explains a lot.
I think he was involved from a very young age, it appears,
Yes.
and may have been part of the system at the time when the wheels used to turn.
Uh-huh. Thank you.
Yes.
Grateful, Your Honor.
Yes.
Your Honor, I was just adding by the by that he is now, I believe, the assistant librarian at the prison. So he has used the time well, I think.
Yes.
And it's
But that's
almost
purely
finished.
anecdotal.
Yep.
And almost finished indeed, Your Honor.
Yeah. Yes. Yes. Thank you, Mr. Pilgrim. Miss Delaney, is it?
Yes, yes, sir.
Go ahead, please.
524.
Your Honor, in this city, I would deal with wrong which my dealt with last.
We're not hearing you, ma'am.
I will deal with the ground which my learned friend dealt with last, which relates to the circumstances of the appellant absconding from his trial. And it's my submission, Your Honors, in relation to that the learned trial judge did everything that he could to ensure that even in his absence, the applicant had a fair trial. The counsel for the appellant or the applicant has stated that the co-accused made certain statements, and the trial record reflects that immediately after making those statements, the judge made a comment to the jury and the co-accused that he could not make those statements, and that he was not to make statements such as that again. And in his direction to the jury during the course of the summation, his lordship told the jury that they were not to first speculate as to why the accused, as he then was not present at his trial, nor were there to draw any inferences as to guilt because of his absence. The learned trial judge also put to the jury what the appellant's defense was, the fact that he said he was beaten to secure the statement, and that he was subject to various to oppression, and that was put to the jury during the course of the summation by his lordship. Of course, during the voir dire, the appellant did question, cross-examine the lead investigator, so we are able to glean what his defense was from that, and he had no questions for the board for the backup officer, and he did make an unsworn statement during the course of the voir dire. So the learned trial judge was able to put some of his defense as relates to the statement and the orals to the jury. It's my submission, Your Honors, that the case does not, there was no serious miscarriage of justice in the court below, nor does this case raise any point of public importance, nor does the appellant or the applicant nor does he have an arguable appeal. The learned trial judge did consider all the provisions, all the considerations stated in the case of Hayward, which deals with similar circumstances when the accused person is not at trial and proceeding in his absence. And the learned trial judge did give consideration to those things. The considerations were pointed out to the trial judge by the prosecutor. And it's my submission that in the circumstances of the case, the trial judge made the correct decision. And like we said, Your Honors, that the decision of the trial judge was plainly wrong. As relates to that point, Your Honors, I rely on my written submission. And the constitutional point as relates to separation of powers, as Your Honors can glean from my written submissions, my submission is firstly that the Constitution allows for Dame Sandra Mason to give a decision after she has vacated the post of being a judge. And further, even if Your Honors were to find that she was incorrect to give that decision, it is now a moot point because the decision of the court was a unanimous decision. There are two other justices of appeal that agreed with the decision, and therefore the decision would be a moot point now, in essence. And I have relied on a decision from this honorable court, which about the fact that the court does not decide matters which are moot, and that is the decision of Satio Basdio and Roxanne Hill against the Attorney General of Guyana, and that's a 2018 case in this honorable court, in which the court says that the court will not decide matters which are moot. And it's my submission that
sorry, I didn't get you. In which this court decided that what?
In that case, Your Honor, this honorable court stated at paragraphs 19 and 20. In paragraph 19, the court started out by saying that the appeal had now become academic. It was now a moot point. And the court concluded at paragraph 20 that to hear matters that are moot would be an abuse of the court process because their decisions would have no consequences. And courts do not decide cases for academic purposes. Judicial orders must, above all, have practical effect.
Yeah, but why do you say that this case is moot? This conviction is moot?
No, in relation to the constitutional point, because it was a unanimous decision. There were three justices of appeal that agreed that the conviction should be upheld. And even if, in my submission, Your Honor, it was to be stated that Justice of Appeal, Dame Sandra Mason, should not have given a decision, there are still two other law lawyers that agreed that the decision should be the conviction upheld and the sentence upheld, affirmed, and there.
Counsel, Mr. Pilgrim says that the fact that a third person was part of the deliberation process, who should not have been part of that process, tainted the whole process. And I think he cited a case of Stubbs, which he also shared with you, to support that point. How do you respond to that?
Well, as Mr. Pilgrim stated, Your Honor, I haven't had the opportunity to read the case in depth. I only got it this morning just before court started. However, in reading the paragraph surrounding paragraph 33, which my learned friend has relied on, I submit that this case can be distinguished from the present case. In the case of Stubbs, the court found that there was, this is that paragraph, crave the court's indulgence.
That's the appearance of life.
The court found that there was the appearance of bias. This case involved, as my learned friend stated, where the High Court judge subsequently became a Court of Appeal judge, and in the High Court he had heard the trial. He had made numerous rulings, including a ruling on a no case submission. So he had intimate knowledge of the case, and he had made rulings which would suggest that he had a particular persuasion as relates to the evidence in that case. So the facts of that case are very different to this case, where it's my submission that it cannot be said, even if her ladyship had given the decision or was involved in deliberations after she had been a governor general, that there was any apparent bias or obvious bias as relates to her role in giving a decision.
Well, it wasn't bias that he was looking at. I think he was looking at the fact that she was then part of the executive, and as such, for her to take part in deliberations would have been a breach of the separation of powers.
Yeah. But it's my submission in relation to that the Constitution does allow for such a situation to take place. The Constitution does not. The section which states that a retired judge can return to give decisions is not subject to any caveat. It simply says that you can return, and in the circumstances, it's my submission that would allow for the Governor General to give a decision as a Justice of Appeal for a decision that she heard while she was a Justice of Appeal.
So in the example he gave, then you would be of the view that the judge who became the DPP could also deliberate and give judgment in the case that he had been involved in as a judge?
But that case will actually be more analogous to the case of Stubbs, where there was clearly apparent bias in that scenario.
Yes, but in the case of the DPP, you would agree that the Constitution would not allow that person to deliberate after they had become a DPP.
Well, technically speaking, in my submission, the Constitution would allow the person to be but the question would be, I agree with Your Honor that they shouldn't.
Yeah. What about the point raised by the President that we have to assume the regularity of what occurred?
I agree with the court on that point, Your Honors.
Okay.
There's no evidence to suggest that there was any impropriety. There's no evidence to suggest that the deliberation did not take place before Dame Sandra was elevated to be Governor General, and it's my submission in circumstances we cannot assume that the wrong thing was done.
Thank you.
Yes, is there anything else that you wish to urge?
No, Your Honor. Those are my submissions, and I rely on my written submissions, which I filed with the registry of this honorable court.
Thank you.
Ms. Delaney, you said that the trial was fair, but I understand that the trial happened 8 years after this crime had been committed, correct?
Yes, Your Honor.
So
The day of the offense.
Can a trial be fair after such a long time? Just wondering.
It's not ideal. It's not ideal, Your Honor, but it's my submission that yes, the trial can be fair.
Okay.
Your Honor, if my friend doesn't agree with that, we're in big trouble here.
Okay.
Replies, President?
Yeah. Mr. Pilgrim, I was operating on the assumption that you didn't want or need to reply.
I think that's a reasonable assumption.
Okay. We take 10 minutes and then we return.
We're grateful to you, Your Honor.
Court rise. Please take your seats.
Yes, Council, we reached a decision in this matter. In some respects, this matter is very unfortunate. The journey between the time the prisoner was charged and now has taken 17 years. And even though some of that time was contributed to by the applicant himself or by his counsel, that is still an inordinate length of time. And it is not something that we can condone. In relation to the appeal or the application for special leave to appeal, I think the grounds or the basis upon which such an application would be successful are pretty well known. The bottom line is that there must be an arguable case. We have examined the grounds put forward by counsel. They can be divided into two sets. The first set relates to the constitutional point. And in our view, there really, at the end of the day, is not much in that point. As counsel candidly conceded, the point really was premised on an assumption on which there was no evidence. And in the absence of evidence, one way or the other, as to when the Dame Mason would have deliberated as a judge of the Court of Appeal, we cannot assume that this was done beyond the time when she was a judge. And the Constitution is very clear that at least in relation to those circumstances, then a person is fully entitled, a former judge, to do whatever is necessary in relation to matters which were commenced before they demitted office. So we didn't think that there was much in that point. In relation to the other set of grounds, namely that the trial judge had conducted the trial in a manner that was unfair. Again, having looked at the way in which the trial judge sought to deal with a novel and difficult situation, we thought that the judge did what was appropriate and that there really isn't any arguable ground to suggest that the trial judge's summing up or the trial judge's conduct of the case or the trial judge's decision to proceed with the case in the absence of the applicant who had taken it upon himself to abscond, that there was anything to suggest that the trial judge did anything other than what was reasonable. So in all those circumstances, we would dismiss the application for special leave to appeal.
As the court pleases, Your Honor.
Yes.
With your leave, I'm a little bit sensitive because of circumstances here. I just wanted to be clear that when you refer in your judgment to the delay caused by his counsel, that it is not including parties
His counsel, not
I think, Mr. Pilgrim, that our earlier indications were such that you are absolutely regarded as blameless and, in fact, a paragon.
In fact, I repeat, I concur in and repeat the remarks made by my brother, Justice Barrow, in relation to your representation of the accused. And we have nothing but commendations for you, Mr. Pilgrim, in this regard.
Grateful to you, Your Honor.
Yes.
Court rise.